When people talk about a plant or substance being illegal, they often don't actually know what that means, and usually just assume, because they've heard it somewhere, they saw it in a movie, heard it on news, which might be from overseas. Terms like Schedule 1 drug or Class A drug are usually referring to UK and US law rather than Australian law. So when people mention those sort of terms, you can usually assume that it's not actually local knowledge. In Australia, we have two levels of drug legislation, the federal and state. We'll start with the federal law because that's actually less powerful. The drug law used to be almost entirely a state-based law. Only over the last 10-15 years, the federal government has sort of taken parts of the legislation on themselves. Most of it is in the form of recommendations, so that the law, or what the federal government says should be law, doesn't actually become law unless the state government agrees to it. Because of this arrangement between state and federal, the best way to actually change drug law in Australia is to do it on at the state basis, because even if something is prohibited at the federal level, if the state law exempts that particular substance or plant, that actually overrides the federal law. The most comprehensive listing of drugs and poisons is maintained by the Therapeutic Goods Administration, the TGA, and it's in the form of the poisons list, or also known as the Standard for the Uniform Scheduling of Medicines and Poisons, the SUSMP. Used to be called the SUSDP, as in the Standard for Uniform Scheduling of Drugs and Poisons, but it's just been renamed a few months ago. Schedule 1 is empty, and Schedule 5 to 7 deal with household industrial chemicals, so we'll just ignore them for now. That's why I've greyed them out. Just want to make sure that when we talk about schedules, we actually talk about schedules for one particular act. Many acts have schedules attached to them. They're subordinate legislation, and if you're talking about Schedule 4 in the Customs Act, it means something completely different to Schedule 4 in the Therapeutic Goods Act. So you always need to be clear about which particular act you're talking about. In this case, we're talking about the Therapeutic Goods Act. A quick glance at the schedule shows that Schedule 2 is a pharmacy-only medicine. Schedule 3 is a medicine that requires pharmacists to actually be involved in the sale, so you actually have to talk to the pharmacist to get it. A Schedule 4 is a substance that requires prescription, and Schedule 8 and 9 are for substances that have a high level of abuse potential and danger. So S8 are substances that have this high level of abuse potential but need to be available for therapeutic use. Schedule 9 is regarded as having no therapeutic use. Schedule 8 and 9 are enforced differently in various states, but in most cases they're enforced under state drug laws, which is different to Schedule 1, 2, 3 and 4, which are enforced under therapeutic laws. The TGA schedules, as I said before, aren't actually law, so the TGA will make decisions. They go into a book and get released, but it's not until the state government says, yes, we want these schedules to actually become our state law, that's when it becomes law. Problem is that over the last 10 years, all the states have put clauses into their Therapeutics and Drugs Act, which automatically empower the federal schedules. So as soon as something gets put into 2 to 4 or 8 and 9, it automatically becomes part of the therapeutic schedule or the drug schedule in the various states. States can add or subtract from federal schedules. So for example, in Tasmania, when industrial hemp was first started there about 15 years ago, they had to actually change the drug schedule to override the federal legislation so that they could actually grow cannabis plants there for hemp production. In South Australia and ACT, because of their decriminalisation efforts for personal cultivation of cannabis, also exemptions had to be written into the law, which override the federal legislation. Western Australia went the other way. They've added kava into their drug schedules. So whereas in all other states kava is scheduled under therapeutic law, in Western Australia they've actually added kava into their Schedule 9, which is the drug schedule there. So kava is treated in the same way over there as heroin or amphetamine. In pharmacies, it's easy to spot what schedule a product belongs to. S2 has a warning to be pharmacy only. You can see up there, the pharmacy medicine. S3 is pharmacist only, and S4 is prescription only. It's not so easy when you're dealing with dried herbs and herbal products, because you just get a live plant or you get a dried herb. It doesn't necessarily come with the label. Live plants, however, can never be scheduled under S2 to 4 because the therapeutic schedules require that the product is actually a preparation, and I'll get into the definition of preparation in a moment, but basically a live plant cannot be a preparation. So Schedule 2 to 4 cannot include any live plants. The SESMP lists plants by botanical name followed by their intended use. There's often limitations applied to a species, and you have to actually read every single word there because it can make the difference between whether a product is scheduled or unscheduled. Here's a list of S2 herbs and substances, just to give you a feel of what herbal products and mind-altering substances have attracted the attention of the regulators at the lowest level. The schedules often limit application of the restrictions in certain ways. So, for example, any preparation containing gelsemium for any purpose requires a prescription. However, datura is only prescriptive when used orally. If you smoke the leaves or rub an ointment on your skin, then this is not restricted for datura. S3 herbs and substances, there's not much to see here except for pseudoephedrine and codeine, which are here not because of their potential harm, but because of their potential for abuse and their use as precursors in manufacturing drugs. Now, S4 is a big one. These are all the herbs and substances that you're only allowed to possess if you have a valid prescription. Mere possession charge is probably just a slap on the wrist, but if you were caught selling any of these products, that would be dealt with similar to a small-time drug dealing charge. Notable herbs in this group are angel's trumpet, Brugmansias, ephedra, mandrake, kava, and tansy. And now tansy is an interesting one because I went to the herb shop the other day and saw that they were selling Tanacetum vulgare, which is tansy, and it turns out that it's actually an S4 substance, but because it was grown on the farm and the plants themselves were never scheduled, when the farmer harvested it and supplied it to the herb shop, he wasn't aware of the scheduling. So you've got to be aware of these schedules, otherwise you can get yourself into quite a bit of trouble. There's quite a few relatively common herbal products there, or at least common overseas, maybe not so common in Australia. So if you're importing any of these, you're actually importing a prescription medicine. Again, you need a prescription for that. The second column contains a number of plant-derived substances. Until recently, the TGA was very clear that the schedule only applies to pure substances. More recently, they have actually prosecuted people for having herbs that contain some of these scheduled substances. One example would be betel nuts, which contain aracholine. So aracholine is in S4. Betel nuts have always been regarded as unrestricted, at least under therapeutics legislation. But more recently, that distinction seems to have blurred, and the TGA is now pursuing herbs that contain scheduled substances. I'm trying to clarify that with the TGA, just how far that goes. So maybe next year we'll know more. There's some obvious problems with that approach of scheduling herbs that contain scheduled substances, or therapeutic scheduled substances, in that there's actually quite a few foods that also contain scheduled substances, such as potatoes contain small amounts of diazepine. Lotus seeds contain apomorphine, and there's a whole lot of different foods that would be included in that. They're only trace amounts, but you've got to make sure that authorities are clear as to where cutoffs are. You can't let them be arbitrary about which herbs are and which products are and which products aren't. There has to be a clear cutoff so that you know as a researcher exactly what is legal and what is illegal. As mentioned before, S8 and S9 are generally dealt with under the State Drug Acts. Penalties for infringement can range from fines to life imprisonment. S8 contains a few familiar substances of abuse, but they do have therapeutic effects, and such as amphetamine is better known as Dexies and used for ADHD. Cocaine is used in eye surgery, and ketamine is used as anesthetic, and the opiates obviously as painkillers. Well, an open-minded person might find similar applications for many of the substances in S9. They can actually only be obtained by permission directly from your state health department, and sometimes even federal authorities have to agree to that as well. The research, this is supposedly not inhibiting research, but in a practical sense, it means that deans of universities or senior staff don't really want to go through all the paperwork, the hassles and the responsibilities of looking after a student or researcher who's actually working with these substances. The amount of red tape involved is phenomenal. We actually have somebody who used to contribute quite regularly to these conferences, Thomas Munro, did a lot of research on salvia divinorum and salvinorin A. But his research was based on, or was focused on the antioxidant properties of salvinorin A. So nothing to do with psychoactive research at all. Yet at the time when he was working on this, actually like halfway through his work, the government decided to schedule salvia divinorum and salvinorin A. So he had to jump through hoops for about a year to get all his permits and paperwork. Now, that obviously inhibits research because most students wouldn't bother doing that. He only did it because basically he had to, because he was halfway through his work. Other students who would be starting a new project would probably just go, no, too hard and leave it at that. And the final result was when Thomas wanted to do further research, he went overseas. There's another federal act that contains federal drug schedules. This is the Criminal Code Act of 1995, which is a relatively recent piece of legislation. So recent that most people who deal with drug matters or research don't actually know about it, because they just think that it's a TGA, it's the state drug schedules that they have to worry about. But it's actually, this one is a very comprehensive piece of legislation, and it's pretty much where all the effort has gone into over the last 10 to 15 years by the legislators. It does not require agreement from the states, so it usurps the sovereignty of the state drug law. And the Criminal Code Act deals with a core set of drugs, their importation, manufacture, cultivation, possession, sale, and their precursors. While the schedules themselves are not very large, like it just has the sort of core set of popular drugs in it. They contain the most comprehensive analog scores of any state or federal drug law. Now, don't worry about reading all of that small print because it's quite complex. But if you're a chemist, it's fairly easy to work out. You know, you're working with a molecule. You know exactly how big, how many changes you can make to the molecule before it becomes illegal or before it is legal. However, then they added this bit down the bottom, F, and basically translated that means anything that's remotely similar to the drug. So it overrides all the limitations it was given up here, which is sort of the standard, like these A, B, C, D, E are pretty standard in most state drug law. And everybody knows pretty much what they're working with. But then F is this catch-all that basically just grabs everything else. So you could be working with a completely benign amino acid that you have no intentions of using for any drug research or anything like that, and a state authority or federal authority could come and say, well, basically it looks very similar and we're just going to charge you anyway. Whether you end up getting convicted or not is a different matter. As far as I'm aware, there's only one case actually pending under Section F at the moment. Again, we might know more in a couple of years. The people who research and import their own materials usually keep a close eye on the Customs Act because if you're importing drug-like substances, you have to make sure that you're not infringing on any customs schedules. However, for the last 10 years, almost nothing has been added to the customs schedules because essentially the federal government is putting everything into the Criminal Code Act, which actually has a what's it called, the Border Controlled Drugs section, which is basically a de facto customs import schedule. Now that is quite substantial, and again it has this clause F in it, where which there's this huge catch-all that if they've kind of missed something in the rest of the analog clause, the section F will just catch it. Now to the illegal plants. There have been 3 illegal plants for many decades now, which are the result of international drug treaties that Australia's a part to. Now, the drug law was sole domain of the state law at the time, so it was implemented by actually each state making their own law to prohibit these 3 plants. Now, there's slight variation in that. Most states just prohibit the coca bush, or coca bushes that contain cocaine. New South Wales, as a result of paranoia and ignorance, they've prohibited every species within the genus, and that includes the one that grows natively in New South Wales. In June 2002, the TGA added Salvia divinorum to Schedule 9 of the SUSDP, which was called then, which made it the first live plant to be restricted by this process. In May 2004, the same process also made Metagenia speciosa illegal. Since that time, most states have added these 2 species to their own drug schedules, even though they don't need to, because, as I said before, the state drug schedules give power to the federal schedules. These 5 species are still the only species that are federally prohibited. All other live plants are legal unless prohibited by some other state law. Now, I mentioned earlier that I was going to talk about the definition of a preparation, because that's quite important with therapeutics law, but it's even more important when you're dealing with drug law. The way state law deals with live plants varies greatly from state to state, but at the core of most relevant legislation lies the definition of preparation. This term is extremely important in drug law and also the source of much of confusion. In the UK, for example, preparation requires some process, human intervention process, such as grinding or extraction. In other countries, it's something as simple as drying the herb, like picking it or drying it. In Australia, and I've got this directly from the TGA, the definition of preparation is picking it. Harvesting. So you can have a live plant, like a cart plantation. As soon as you go and take a few leaves or twigs of that, that is then called a preparation. So even though you've got just as much cathine and cathinone illegally in the live plant as in the bundles, that's legal, that's illegal. There's some exceptions to this concept that all plants are legal, in that Queensland doesn't use the term preparation. Queensland, or they used to, but 2 years ago they changed it. They now use the term thing. And plants, in about the strictest definition, are things. So any plant with an illegal constituent in Queensland is actually deemed to be that illegal constituent. So if you have a cut plant that weighs 2 kilos, you actually have 2 kilos of cathine or cathinone. That's what you'll be charged with. The same applies to mescaline bearing cacti too. So all the Queensland collectors who have large variety of cacti, many, dozens of them contain traces of mescaline. Essentially under Queensland law, they're all illegal. In South Australia, the law specifically schedules Catha edulis and also mescaline containing cacti. So there's not a matter of the definition, they just blatantly schedule all mescaline containing cacti. Which is kind of absurd if you think about it, because it's so many of them are popular garden plants. You just drive through average suburbia and there's mescaline drug cacti everywhere. By far the most comprehensive law prohibiting drug plants is in the ACT. Now you've got to remember that the ACT is a fairly new state, well not a new state, but it's self-government in the ACT is fairly new. So they were a bit in a rush obviously to write their legislation, because it appears that some board public servant tried to make the list as complete as possible. So complete that they included some species twice. Where they used both defunct names and current botanical names. You've got Hemidictyon amazonicum and Prestonia amazonica is actually the same plant. Upon close inspection, the source of this long list becomes much more obvious. It is actually, for the most part, an index of a very old ethnobotany book written by ethnobotanist Schiltes. And both, Prestonia amazonica and Hemidictyon are not known in cultivation. They're only known in South America, growing wild. I couldn't find any botanic garden records of them growing anywhere else. So for the ACT to presume that it's a threat to their public health is a little bit ridiculous. Now, that might all sound quite amusing of how they go about making laws, but you have to remember that these laws inhibit your freedoms. They limit your freedoms. And we have a right in democratic countries that our laws are created according to the best scientific knowledge available. Drug law is not very well known for following that principle, but I think these sort of examples are just too ridiculous to actually let them get away with it. Yeah, we need to make sure that our governments make laws that are at least justifiable, not just ridiculous. And it gets even more ridiculous because at this stage it seems like the Pressonia species wasn't even correctly identified as a DMT-containing plant. So they've actually scheduled a plant there twice, which probably doesn't even contain any DMT. Now, things get a bit more complicated with mushrooms. One would assume that if cultivating cut plants is legal, or any other plant that contains an illegal substance, then so should cultivating mushrooms that contain illegal substances. The courts don't seem to agree with that. That might be because the only reason for cultivating psychedelic or psychoactive mushrooms would be for consumption. I can't see of any other, I don't know of any court cases that have actually tried to prove that this was just for mycology purposes or spectroscopy or something like that. Cultivating psilocybin or muscarine mushrooms is regarded as possession of that substance, or even worse, manufacture. If you get caught with a large mushroom cultivation chamber, then you could actually be looking at a manufacturing charge rather than just possession. All psilocybin-containing species are scheduled in all states. While some states also schedule the whole genus Psilocybe, if any species or the whole genus is scheduled, then this would include all parts of the mushroom, including the spores. And as muscarine is federally scheduled as S9, this makes Amanita muscaria mushrooms illegal as well. A lot of people think that Amanita muscaria mushrooms are actually legal, but it's actually under federal law, which is enacted under state law, they are actually also drugs. One of the scariest examples of drug legislation is about a group of compounds called the beta-carbolines, harmine and harmaline. They're the active constituents in a number of herbs, including Banisteriopsis carpi, the ayahuasca vine. Now, low doses of harmaline and harmine don't have any effect themselves, but they're actually consumed to inhibit the enzyme monoamine oxidase, which then makes DMT orally active. That's the whole concept of ayahuasca brews. To do that, you only need about 200 milligrams as a minimum. The effect of 200 milligrams might be some mild sedation. So it's certainly not something that would need to be scheduled at that sort of level, because it's quite harmless at that level. The New South Wales legally defined discrete dosage unit is 200 micrograms. So 1,000th of what would be a May inhibiting effect. That's not even a drug effect, because you need about 500 milligrams to actually feel the harmine or harmaline, whereas you only need the 200 milligrams for the May inhibiting effect. Now that means if you're taking one mild ayahuasca dose, you're legally taking 1,000 doses under New South Wales law. So in a nutshell, New South Wales law regards a single dose of ayahuasca as worthy up to 20 years jail term. Now, there doesn't seem to be any case law that actually supports that. It seems people who did get caught with ayahuasca, because of community connections and whatever, community standing, they managed to not have to deal with these sort of penalties, but certainly the charges were that high. So if you get caught with a bottle of ayahuasca brew, which might only have one dose in it, so we're dealing with this sort of quantity, when you actually get charged with it, you're getting charged with a commercial quantity of drugs, which means somebody in your family will have to put up their house as surety. It's not a $2,000 bond, to get you out of jail. It's going to be substantial. It's going to be hundreds of thousands of dollars value to get you out of jail. And that's just to be on bail. Then probably a couple of days before you actually go to court, they'll probably drop it down to next to nothing, slap on the wrist. But in that meantime, you're being dealt with as a drug dealer of a large commercial commercial quantity or large commercial quantity. I've cut and pasted the table for LSD above the harmaline for comparison. So we're talking commercial quantity here, which is the 500 milligrams. You got LSD, lysergide, and harm in there. They're all identical. So that makes me think that when this law was written, they got a chemist to go and have a look at the structure and go, oh yeah, it kind of looks a bit similar. Let's just stick them all in the same legislation, which is ridiculous because under pharmacological principles, there's a huge difference. And again, we're back to using science, the best available science for making legislation. This isn't it. Now, years ago, it was extremely difficult getting legislation. You'd have to go to your government bookshop to purchase legislation. You'd be paying $10 for a little booklet, a couple $100 for a full act. After a year, when things change, you'd have to pay the same again to stay up to date. These days, all you got to do is get online. Each state has their own legislation website. Quite easy to remember. And the federal government also has its own website, and all this legislation is available online. You have some more direct links written in the article that's in your EGA journal. I encourage you all to make use of that, because the only way that we can change drug law and the only way that you can stay safe when you're doing your research is that you actually know what the legislation is. Thank you.